people and got the word out. We used the social media, stuff I didn't know about a little over a year ago, Twitter and Facebook. We had yard signs, and we had grassroots activists who went out on busy street corners in St. Louis and all over the state with yes on Prop C signs. And the voters got it. And I told Greta Van Susteren 2 nights ago that an F5 tornado set down in Missouri and swept through all 114 counties, and we had a 71.4% majority for Proposition C. Now comes those who deride the effort, as they have all along. By the way, I think they have a logical fallacy, Congressman, in their argument. If the effort was meaningless under the Supremacy Clause and of no effect, and it was a nullity and a dead letter, why was it worth trying to beat? Of course, they never answer that. But now they come to say it's of no effect. If you read the New York Times, they quoted somebody saying it's of no effect. Some of these people are the same folks, the same left-wing law professors who parade on the cable shows saying that the lawsuits springing up across this country are frivolous, that they lack standing, that there is no legal ripeness, and on and on and on in an attempt to laugh them off as frivolous and without merit. But one by one, those arguments are being shot down, aren't they? And from the great Commonwealth of Virginia, we had Judge Hudson's opinion on Monday of this week, even before the good news in my home state, that he, in a well-reasoned, tightly written 32-page opinion, he denied the federal government's motion to dismiss Attorney General Cuccinelli's case and said this will go to the full hearing. And because of the profound 10th Amendment and other constitutional issues implicated in that lawsuit. He pointed out, Judge Hudson did, that nothing like this has ever been litigated, nothing like this has ever been attempted by the federal government. And if we concede this principle, that under the Interstate Commerce Clause or the taxing power or anything else they're using to try to justify it this week, the federal government can do this individual mandate, then limited constitutional government, any vestige of it is gone and the game is over. We will wake up someday, I've been suggesting, and read that the government has decreed that you may not buy a Ford, a Toyota, or a Mitsubishi, and you may buy only a Government Motors or a Chrysler. And people laugh and say, well, that would never happen, but look at the fantastic series of events over the last 18 months, that all of which had never been contemplated before and are now coming to reality. Well, so these issues are all enormously important. I was asked to tell you a little bit about the constitutional challenge I filed, and so I'll conclude with that. On the 7th of July, a brutally hot, humid morning in the Mississippi Valley, I stood at the Rush H. Limbaugh Federal Courthouse in Cape Girardeau, Missouri, named for his grandfather, who I knew the first 40 years of my life and went to church with, and we called Rush, the one you hear on the radio, Rusty, to distinguish him from his father and his grandfather, who were Rush Sr. and Rush Jr. But Mr. Rush practiced law for 80 years in Cape Girardeau, died at 104 and had practiced law till he was 102. So and was a towering legal scholar and pillar of everything good in constitutional teaching and personal rectitude. In any case, the federal courthouse is named for him. I love to mention it. And we brought a lawsuit, a constitutional challenge, that is to be distinguished from the ones brought by the AGs. And God bless Attorney General McCollum, and what is he, up to 20 states that have joined the Florida suit? 22 states that have joined the Florida suit? And Attorney General Cuccinelli, but they are suing in those two suits as states. I was basically barred from doing that because I was the only survivor of the Obama tornado in 2008, and I'm the only Republican out of 6 constitutional statewide officers in Missouri. So I decided to take a different legal tack in filing our lawsuit. And I recruited 3 Missourians who happen to all be females to join me as individual plaintiffs. Now, we distinguish the AG's case legally from ours in the following manner. Theirs is called a facial challenge. That is, they're suing on the face of the constitutional, their argument constitutionally is, this law is unconstitutional on its face. That is the legal scholars tell us, a somewhat higher standard, a significantly higher standard to get that, and a higher hurdle to, or as Kip Bond would say in our state, a higher stump to jump. The individual plaintiffs in my lawsuit, who I'll tell you about in a second, we're bringing an as-applied, not a facial challenge, but an as-applied. We're saying, as this law is applied to us individual citizens of Missouri, it will wreck our health care and wreck our state's finances, and therefore is to be struck down. We're making many similar arguments, but it is distinguishable on that basis. It's also distinguishable on the basis that if you have an attorney general or a governor, I was talking to Haley Barbour last week, and he said his attorney general wouldn't file, so Haley filed. Haley joined in the state lawsuit. But if you're in my case, and your AG and governor won't join, then I'm denied the state's purse in bringing this lawsuit. So I'm privately financed. I'm accepting, I have my tin cup out, and healthcareinaction.com. If anybody has 25 or 50 or $100, you can send me for my $50,000 to $100,000 legal bills. I have general counsel at Fox Arendt law firm that has won a case in the United States Supreme Court. They won the big voter ID case. We like our chances in where we are in the Eastern District of Missouri because we will go through the 8th Circuit Court of Appeals in St. Louis, arguably the most conservative of the state courts of appeal. The circuit courts of appeal around the nation. But our 3 plaintiffs joining me are a 75-year-old lady on Medicare Advantage, a good program, a program that allows her with a multiplicity of health problems to include having survived colon cancer, a quadruple bypass, and battling congestive heart failure. She says, I need access to good physicians at Washington University Medical School in St. Louis, some of the best on the planet. And since Medicare Advantage is being shut down, since it's a good program, it's of course being eliminated step by step under the new Obamacare, and she says, I'm going to be thrown onto Medicaid, 4th-rate delivery of health care, and so if I lived in Florida, because of the Gator Aid provision to buy Senator Bill Nelson's vote, you're allowed to keep your Medicare Advantage, but the citizens of 49 other states are denied this good program. What is the rational basis for a distinction like that? There is none. That will not survive a rational basis test, we believe, and can be said to be indisputably a denial of equal protection of the laws guaranteed to all Americans under the 14th Amendment. Plaintiff number 2 is a middle-aged, 40-something mother, widowed mother of 2 adopted boys, the younger of whom is autistic. And she says, this law is going to wreck my special needs child's health care. And plaintiff's number 3 is a 21-year-old recent college graduate, Samantha Hill, and Samantha Hill says, I'm healthy, I eat right, I exercise, I neither smoke nor drink, I'm 21 years of age, I don't need the one-size-fits-all policy with all kinds of bells and whistles on it. For instance, I don't need smoking cessation coverage, and I don't need substance abuse counseling coverage, and all I need is a major medical policy with a catastrophic insurance coverage. And yet I'm being forced to buy, with my very limited means as a 21-year-old kid, a policy that is completely unsuited for me, and so that's her claim. So ours is unique in bringing those claims, as far as I'm aware, among any of the lawsuits. And As I say again, God bless the others, the AGs. I hope they succeed and go all the way, and it's entirely possible that under the federal rules of permissive joinder, we will meet somewhere and be joined together. But I wanted you to know about that. And I'll conclude and say that I'm enormously heartened to have a brochure here announcing the Patrick Henry Caucus. You remember every schoolboy and girl used to learn, I hope they still do, the words of his "Give me liberty or give me death" speech. But as stirring as that line was another line. We're arrayed against enormously powerful forces, you know, just like the colonists to whom Patrick Henry was speaking, confronting the world's mightiest armed forces. We in this room are arrayed against the media, the academy, the majorities today in D.C., with all their power. But Patrick Henry said, "The race is not always to the swift, nor the battle to the strong. It is to the vigilant, the active, the brave." Let's be all three of those, and we will prevail.
And speaking of Twitter, everybody smile. All right, very good. Okay, so we have a happy problem. There's probably 50 of you that want to turn at the mic, and we have only a very short time. So I have to ask you to keep your questions short and your speeches even shorter, okay? We don't really have time for speeches. We barely have time for statements. We'd like to get in a few questions, and we'd like to give you the best crack we possibly can at these distinguished panelists, but we're also not going to make you late for lunch. Okay? And can I ask, is Matt Shea here? Matt, if you want to turn at the mic, would you please step forward? Let me ask Matt to start things off. Matt, please introduce yourself, and please be very disciplined about the time that you consume so that we let other people have a shot. Let us know if you're directing your question at a specific panelist, and they can answer from the table.
Absolutely. My name is Matt Shea. I'm state representative in the 4th District, state of Washington, Spokane Valley. Several of us state legislators drafted a step-by-step plan for freedom along the lines of the 10th Amendment and restoring state sovereignty. And we put that out on the internet. I'd like to make a plug for the 10th Amendment Center because it has all that model legislation there, and it's a great reference and resource for everybody that's here. My question is this: the 10th Amendment is more than just health care, wolves, land use. I mean, there's so many things. Can you give us some examples of where we can apply this at the state level so we can put the federal government back into its constitutionally designed box? Thank you very much, and we're at war in Washington.
My suggestion is, yes, you're right, it's everywhere. I'll give you an example. Next week, Rob and I get to fly back to Washington in the middle of the August break to vote on a measure which Nancy Pelosi is bringing to the floor. It amends the Medicaid Act, but it continues provisions that I think you state legislators are very much aware of, and they are called maintenance of effort provisions, where they tell you that although Medicaid is a federal program, but it gives the states the discretion to decide who gets the benefit, the federal government says, we're going to give you more money, but you cannot cut back or restructure the program the way you think you need to. What I would suggest to you is that you take an example like that, you say, we don't want to restructure our program under the maintenance of effort provisions you have, requiring us to continue to cover all the people you are mandating we cover, so we refuse and redesign the program the way you want, and then let the government, if the government will fail to give you the money, then sue them. In Arizona, you know, the author of Senate Bill 1070 is here. That challenges the authority of the federal government in one area. One federal court has said it's unconstitutional. I think that judge is wrong. Unfortunately, we're in the Ninth Circuit. I don't think we'll get to win in the Ninth Circuit, but I think we have a chance of winning in the United States Supreme Court. But I think you can pick any given area where the federal government is exceeding its power, pick a fight with them, and then go litigate the issue and begin to demand that the federal government acknowledge that the Constitution provides only limited powers to it. I think that's one example, and there are lots of others.
Anybody else want to address that? Okay, let's go to the first microphone. Please introduce yourself, and please be brief.
Sure. Roman Bueller from the Madison Amendment Coalition, and this is a question for Congressman Bishop. You gave a very, very persuasive